My name is Hakeem Mokhtar. I'm the Administrative Director of the Program on Legal Profession, and we're happy today actually to have one of our PIRG recipients, which is the Public Interest Research Grant, Adriana Benedict, here to talk a little bit about her research. I'm going to let her get into the details, obviously, of what it is that she was able to do and accomplish with some of the funding that PLP was able to provide, but I wanted to also mention how some of this research was possible. Of course, there's alternate sources of funding, but PLP provides students here at HLS, whether it be JDs, LLMs, SJDs, funding to support their either public interest, which is PIRG, Public Interest Research Grants, or their empirical research, which is the SIRG grant that we have available at PLP. Some information is up here for you to take after Adriana has a chance to talk a little bit about her research. Without further ado, Adriana.
Thank you. So thank you, Hakeem, and a special thanks to the Program of Legal Profession for funding my research. With the funding that Program of Legal Profession provided, I was able to get this research started by attending the second annual Global Congress on Intellectual Property and Public Interest in Brazil last December, actually just about a year ago now. And then this summer, I was able to attend a first round of negotiations for the proposed US-EU transatlantic trade and investment partnership in Washington, D.C. And through both of those forums, I was able to meet a lot of people who have been really invaluable to helping guide my research and point me in the right direction of sources and how to really track down some of these more difficult, some of this information which is more difficult to find, given that a lot of times it's shrouded in secrecy and not really exposed to the public for public comment. So I'll go ahead and get started. My presentation is Tailored for the Commons, Form Shifting and Fine-Tuning of Public Interest Policy Spaces in the Global IP Realm. So I'm going to begin with describing really quick what IP has to do with the public interest, and I'm sure many of you know some about this. And this is a non-exclusive list here, as is most of my presentation. I'll include a lot of examples, and they're always non-exclusive examples. There's many more examples that we can talk about if we have more time during question and answers. So primarily, IP in the public interest implicates, intellectual property provisions can implicate public health, individual health, culture and education, privacy, and free speech. And we see some overlaps between trademark and copyright and between trademark and patent law. So with respect to patent law, the main kind of public interest commodity that is concerned is medicines. Intellectual patent provisions help incentivize what gets developed and what doesn't get developed, importantly. And we've seen in the global medicine landscape, greater incentives to produce medicines that serve the needs of those in the developed world as opposed to those in the developing world who have less less effective demand power and ability to pay for costly new medicines. It also affects price competition and the ability of generic companies to enter the market and compete with branded companies at lower prices to provide for developing countries which may not be able to afford the high prices of drugs we pay here, which help support a robust research and development industry. Similarly, more recently now that we are seeing finding new ways to develop generic biologics, otherwise known as biosimilars, there are some debates about the levels of patent protection and data exclusivity that should be attributed to biologics, given their unique status as molecules that are difficult to replicate exactly, and they're also very expensive as treatments for patients. Also with medical devices, we see some debates in the public interest realm regarding the extent to which new uses of generic medical devices should be patentable. Similarly, with diagnostic, therapeutic, and surgical procedures, here in the US, we have a physician's immunity statute, which was developed through a public deliberative process in the mid-1990s in response to some backlash to a lot of infringement suits that were brought against physicians, preventing them from providing care appropriately to their patients. So we developed a physician's immunity statute, which effectively immunizes physicians for any patents on diagnostic, therapeutic, or surgical procedures that they may infringe during the provision of healthcare. And this is a particularly important example to keep in mind because as we're looking in a little bit at some of the provisions in international treaties, which are effectively exported from US law into the law of other countries, but may not be exported with the same kinds of exceptions we've developed here through a democratic process. Similarly, there's a lot of debate amongst public interest-minded folks about the patentability of gene sequences. Just this summer, I'm sure you guys heard about the Myriad case where the Supreme Court decided that gDNA cannot be patented because it's a naturally occurring phenomenon, whereas cDNA can. And relatedly, patentability of genetic tests and various uses of genetic sequences that can still prevent competitors from providing secondary confirming genetic tests that are necessary for patients to confirm whether or not they have a genetic condition.
Can you give an example of the diagnostic or therapeutic exception? Like what were physicians being
It was what prompted the physician's immunity statute was patents on eye surgeries. So it was actually specifically a cataract surgery that was developed by a doctor named Dr. Palin. And a lot of medical associations got together and basically brought this issue to the attention of Congress, and more or less there was universal consensus that physicians should not be held back in the provision of medical care by patents on procedures because the incentive structure for physicians to develop procedures is very different from the incentive structure for say, the development of drugs or devices, as physicians already have kind of built-in incentives to develop these things, and a lot of time when they do, there's a natural sharing and teaching that happens rather than more of a closed, exclusive right to practice.
So, in other words, if somebody comes up with a new way of doing a surgery, and another doctor can just read about it and just do it, if they're skilled enough to.
Yes, there are 3 exceptions in the Physician's Immunity Statute, which is an amendment to the infringement part of U.S. patent law. And 3 exceptions are for biotechnology, for uses of patented devices, which was the previous example, and third one is for non-commercial, for commercial uses that are outside the domain of healthcare. So if for some reason you're performing these procedures in a commercial way, that doesn't, it's hard to imagine how you would fit into that exception. Yeah, there are 3 exceptions. With regard to trademark, less people focus on trademark in the public interest world. However, there are significant impacts on public health. Recently, a number of countries, including Uruguay and Australia, have begun to regulate plain packaging of cigarettes, which has raised a number of trademark suits against those countries at the international level for basically taking away their right to color and label their packages as they would like. And with drugs, the trademark issue comes up with generic pill colors, which patients come to rely on the color that was originally used with a brand name drug. And it's been shown through a study which I believe is in the Lancet, that in fact patient adherence to their medicines depends highly on the medicines being the same color if they're taking them in generic form. Similarly, with free speech, trademarks, the level, the strength of which a trademark owner can stop others from creating social commentary using their trademarks is another important issue that's been discussed in the public interest realm. With copyrights, internet privacy has become a big way to bring in actually a lot of attention to a lot of these issues, since everyone uses the internet, and it's become like a hook to get people involved in issues such as the Trans-Pacific Partnership. Networked knowledge is at stake, as is access to education and cultural creativity. And an issue that's really close to my heart, which is access to scientific research, which is, I think, particularly important given that much of scientific research is done with federal funding. A lot of the review process is done with free labor. Certainly the authors aren't paid And we don't rely actually on physical distribution of journals anymore, which largely makes intermediaries such as publishers somewhat obsolete, yet price increases for libraries of journal subscriptions have increased something like 4 or 5-fold in the past decade with no clear justification. And in particular, this affects citizens of developing countries whose institutions can't access or can't afford to pay for very, very steep journal subscription costs. So where does this take us in terms of lawyers seeking to promote the public interest? Basically, we have to strike a balance between incentivizing innovation and creativity and promoting widespread access and benefit, and also between rewarding and protecting creators and enhancing and protecting the commons. Sorry about that. So this space, the policy space in which public interest lawyers are able to assert the interests of civil society in defending things like free speech and public health are in part determined by international IP frameworks, which were established long ago but have since evolved significantly, and in doing so have shrunk this policy space that public interest-minded lawyers generally can operate into basically design or help influence the design of intellectual property laws within their own countries that reflect the needs of their industrial development and what stage a country may be in as, say, an emerging economy or a developing country or a least developed country with very little R&D, infrastructure, and so on. So the trend that we see in these early international IP frameworks is that they established baselines, they established floors. So they were largely universal, and they were very flexible. They reserved a lot of policy space for public interest-minded folks at the domestic level to be able to legislate in the public interest and sort out some of the fine-tuned details of what their IP laws would protect. So here we see some examples from the Paris Convention regarding patents. There's flexibility for judicial and administrative procedures, flexibility for priority rights, for conditions for issuance of compulsory license, which is important. We'll see later on that these conditions have, this policy space right here has been significantly shrunk recently. Space for trademark filing and registration, details with the Berne Convention for regarding copyright. We see policy spaces reserved to determine the details of fixation, what happens with official texts, art and industrial design, political legal speeches and public lectures, posthumous rights and enforcement of moral rights, pre-existing shorter terms and copyright terms for photographs. Very importantly, fair use. Many public interest lawyers I talked to had very differing opinions about fair use and what is known as the three-step test in international treaties. Depending on what country they came from, some thought that adding, the U.S. definition of fair use to newer agreements was a good idea. However, others noted that the U.S. Fair use doctrine has been developed nearly over a century and therefore has kind of been fine-tuned to address the needs of the United States, whereas other countries who would wholesale just adopt such a doctrine might not then have the opportunity to develop this kind of robust doctrine that we've tweaked over time. A teaching exception, exceptions for current events, the visual archives of ephemeral broadcast recordings, compulsory licenses for musical works, cinematographic works, and here with the Rome Convention we see it's a little bit less universal, but we still see a large portion of the world acceding to it. It's also a little bit less flexible, but still leaves some flexibility for publication or fixation requirements, the effect of performers' consent, joint performers' rights, fair use exceptions, state-by-state reservations, fixation in lieu of nationality requirements, and so on. So these are just some examples, a not exclusive list. So what happened with these international frameworks in 1994 is that they evolved into two agreements. First, NAFTA, which entered into force on January 1st of 1994, and was the first of these agreements that included a provision for investor arbitration. And then the TRIPS agreement, which was largely modeled after NAFTA, but without such a provision. So it did not include any individual recourse for investors. Rather, disputes under the TRIPS agreement are resolved between countries who oppose country. The TRIPS agreement also was established some floors and managed to get many countries on board, largely through many compromises that it set, including exceptions, leaving to the discretion of, I'm sorry if this seems a little fuzzy, leaving to the discretion of domestic governments whether or not they would like, how they would like to develop their system of IP exhaustion, how they would like to balance social and economic welfare, what kinds of copyright exceptions they wanted to create, what kinds of trademark exceptions, what kinds of things they would like to exclude from patentable subject matter. Some were enumerated and others were given a general exception. Some space to legislate against anti-competitive practices, and an exception for de minimis imports. And of course, special considerations for LDCs, most importantly, an extension for least developed countries to implement many of these provisions, which was recently extended, given their levels of development this year. We also, though, see in TRIPS some fine-tuning of the reach and scope of many of these provisions. So we see an inclusion of computer programs and compilations of data. We see specifications for rental rights. We see a new requirement that colors and any combinations of signs be eligible for trademarks. We see the Paris Convention now being applied to services, whereas previously it was only applied to goods. And similarly to another more detailed provision on services, we see more details on geographical indications specifically for wines and spirits. A long list of requirements for governments that may avail themselves of the option to use a compulsory license or other exceptions to the patent rights. A more specific term of protection. So here we see a period of 20 years, whereas previously it was unspecified. A specific provision on process patents, specific provisions on undisclosed information, which is critical for regulatory agencies that approve the marketing of drugs, and a new section on criminal procedures, which also was left out of the original agreements. And finally, dispute settlement between countries. So in this framework, this framework basically became the gold standard and left those highlighted, those yellow spaces open for public interest lawyers and organizations in developed and developing countries to kind of hammer out the details for themselves of how they would like to design those elements of their patent law according to the needs of their own countries. However, since then, we've seen a number of many free trade agreements may further fine-tune these provisions, which has further shrunk the space for public interest legislation dealing with these various areas. So some examples of what these agreements now cover, which basically eliminates the ability of countries to determine for themselves how they would like to legislate on these issues. So these now require patents for new forms, uses, or methods of using a known product, which is a very contentious, these are contentious provisions in the EU. One thing I learned from talking to public interest lawyers in the EU is that they feel very strongly from a moral basis that new forms, uses, or methods of using a known product, if it's practiced on the body, should not be patentable, and they have kind of a very strong history of a moral opposition to this kind of provision if used in respect to things practiced on the human body. Provisions that utilities.
How is that different from the doctor stuff that you discussed? Is this the methods of using a known product on the body? Is that just medical, or is it are these non-medical therapeutic uses?
Sorry?
So when you say patents for forms, uses, or methods of using a known product, are you talking about, does that include uses of product in a medical setting? Is that what the European Union is opposed to, or is it something beyond that.
In the EU, it's anything practiced on the human body, whether dead or alive, doesn't matter. So you would think in a medical setting, anything practiced on the human body would fall into their exceptions. Here in the US, we just make a narrow exception for physicians practicing within healthcare. It's a slightly different exception, but they
Okay, so
obviously
can you
don't
give me an example of something that would fall in one but not the other? Like, what is?
So, for example, we would exclude, so one of the exceptions to the physician's immunity statute is patented ways of using a generic device here in the US that would not, a physician would not be immunized from using a device in a way that's patented if they didn't have a license to do so. Whereas in the EU, there's a strong moral opposition to those kinds of patents.
Oh, okay.
Prohibition on pre-grant patent oppositions, which are a key way that public interest lawyers in developing countries actually try to curb the abuse of the patent system in order to promote access to medicine. So for instance, in India, there are a number of public interest law firms that work only on pre-grant patent oppositions in order to stop the granting of patents that would be invalid before they're even granted, and therefore avoid a lot of expensive litigation that would be required when a generic company seeks to invalidate a weak patent. And those have proven to be very effective in developing countries. Patent term extensions, which extend the life of a patent due to regulatory delays or delays in granting a patent. Patent protection for all life forms has appeared in one FDA. Regulatory patent linkage, which notifies brand name companies when a generic company has applied for marketing approval of a generic drug that is an imitation of their originator drug. And some FTAs include prohibitions on approval of those generic applications until the patent has expired. Many FTAs require 5 years of data exclusivity now, whereas previously many countries had decided not to have any data exclusivity, no, simply to rely on patents or to have different terms of data exclusivity. Many are now required at minimum to have 5 years and 3 additional years for new clinical data. Limitation of compulsory licenses to national emergencies as an antitrust remedy or for public non-commercial use, which has also been critical. Since TRIPS, we've only seen a handful of compulsory licenses issued by developing countries, despite many applications by many public interest firms regarding drugs such as antiretrovirals that are critical for controlling public health epidemics. A limitation of parallel imports through licensing contracts. Copyright term for the life of author plus 7 years, which is an increase from the Berne Convention, which required only 50 years. Technological protection measures against copyright circumvention, domestic copyright exhaustion, and criminal liability for willful infringement, regardless of financial gain. And just a note on the domestic copyright exhaustion, here in the US, we recently did a 180 on our position where the Supreme Court decided that we do, in fact, recognize international copyright exhaustion. It was previously thought that we only recognize domestic copyright exhaustion, so that means that if you were to sell a book outside the US to be sold only in Brazil, then someone under a domestic copyright exhaustion regime could not resell the book, which is copyrighted, in the US. Whereas now, after the Supreme Court's decision earlier this year, anyone can take that book bought in Brazil and manufactured to be sold in Brazil at a cheaper price and sell it in the US for a higher price, basically allowing for international arbitrage. And public interest lawyers come in on both sides of this. Some think it's great because it allows more freedom between markets, and others think it's very worrisome because they worry that now publishers will simply raise prices in developing countries rather than risk someone buying a cheaper book in a developing country and selling it in the developed country. And this is a key place where I found that public interest lawyers were somewhat distraught that they were unable to have any influence in this very important decision, which largely affects their own countries. Much of what I've learned about these spaces for public interest lawyering has been through following negotiations for the Trans-Pacific Partnership, which is an ongoing negotiation between the countries highlighted in yellow. It's 11 countries, and it's expected to conclude this year, although people don't think that will actually happen now. And it significantly, the TPP significantly shrinks the public policy space that developing countries have to legislate in the public interest by specifying a lot more detail about what is required of their intellectual property systems. So, for instance, these are all proposals from the USTR. So there's 12 years of data exclusivity for biologics, which is currently what US law provides for. However, Obama in his budgets has repeatedly sought to reduce that term, and having this kind of provision in the TPP would effectively eliminate our ability to lobby the government to try to lessen that term, even here in the US. Patent protection for new forms and new uses, regardless of enhanced clinical efficacy. This is specifically a provision that is directed to India, even though India is not involved in the TPP, because the TPP is believed that it will set kind of a new gold standard for other agreements. And India has a provision in its patent law that doesn't allow for patents on new forms of known chemical entities that don't demonstrate enhanced clinical efficacy. Recently, actually earlier this year, its Supreme Court handed down an opinion denying Novartis a patent, which raised a lot of international attention around this issue, and may have led to the inclusion of this very specific provision here, which says that a requirement that asks for more clinical efficacy should not be allowed. Also, patent protection for surgical diagnostic and treatment methods without the kind of exception we have here in the US for physicians. Same life plus 7 years minimum copyright term, a permanent knowledge blind and fair use blind technological protection measure liability, copyright protection for temporary forms of digital storage, rejection of international copyright exhaustion, which also currently contradicts US law, trademark protection for non-visual signs, 10 years of trademark protection subject to renewal, no rights management information exceptions for broadcasters, and ex parte injunctions granted with 10 days, which means that the defendant doesn't have an opportunity to appeal before an injunction. And all these issues there's entire public interest organizations that form around these kinds of issues, particularly with regards to the internet and digital storage. However, they've all found that they've now focused all their attention on these negotiations rather than lobbying our own government here to change the law, as effectively what is determined in the TPP will determine the space in which we can continue to legislate in public interest here in the US. So basically, so here we see what's needed is for civil society inputs to be represented by public interest lawyers who can translate them into highly technical IP provisions that find themselves in these agreements and then set law for many countries, including developing countries and emerging economies, which may trade, say, a provision on lower tariffs for a certain agricultural product for a provision on strong IP protections, which may be seen as less vital to the economy at the moment. So part of this response Okay, we'll just zoom in. Part of this response has been to call for more transparency, and we've seen this happen at a number of levels. There was a letter from 132 members of Congress calling for more transparency surrounding TPP, a letter from 400 public interest organizations opposing Fast Track. Fast Track is the now expired piece of US legislation that allowed NAFTA and a number of other free trade agreements to be passed through Congress without any opportunities for revision. And a letter from law professors calling for less secretive TPP negotiations. And this resulted in one congressman getting access to the entire text and issuing this very brief letter saying that he opposes everything he saw in it and will continue to fight against it. He called it NAFTA on steroids. Now, the fact that he was able to, TPP doesn't really help in terms of participation from public interest organizations. So how are they able to comment? So recently, actually, just a couple of weeks ago, WikiLeaks leaked the entire intellectual property chapter of the proposed TPP, including all the country positions. So you can see these little abbreviations showing what countries propose what countries oppose what, and so on, really getting into the details. So this has provided public interest organizations with really fresh new material to revisit their input, which previously was based on a lot of conjecture and guessing about what this agreement would contain. And one thing that this revealed is that the US, in its positions, is largely alone in the TPP negotiations. These lines connect basically who agrees on what based on what we saw here with the little abbreviations. And as you can see, the US and Australia are a little bit isolated in their positions on the intellectual property chapters. And emerging economies have banded together somewhat. So with this information, public interest lawyers attend these stakeholder events, one of which I was fortunate enough to attend. Very eye-opening. What happens at these events is they have two elements. One is that public interest organizations are given an opportunity to present like poster sessions like this, and there's another session where they can meet directly with negotiators and talk to them, representing their interests, and talk to them about what they'd like to see in the TPP. Now, these events are usually about a half day out of, say, a 10-day negotiation round. So it's a very small snippet of participation, but nonetheless, many public interest organizations put a lot of their resources into raising awareness while at these events, particularly for negotiators from developing countries who may have less resources to do their own research about the actual impacts of a lot of these provisions and shrinking their public policy space.
Can I ask a question? Why, aside from the fact that saying public interest inputs seems to have a normative good from the get-go, why should public interest lawyers have more of a say in the negotiation of these agreements?
So,
In other words, why not more inputs from the people who are quite technically knowledgeable about these issues? Why not more inputs from different constituencies? Why public interest lawyers?
So these public interest organizations actually do have highly technical people working for them. So say, for example, the Electronic Frontier Foundation has people who basically focus only on internet privacy and internet security. So they work with jointly with academics, they get a lot of inputs from experts. Usually these public interest lawyers, when they submit, when say they bring documents to these stakeholder events, a lot of those documents are thoroughly informed or even written by academics or outsiders.
So again, so essentially you're making an institutional design argument that in the negotiations of these various, whether it's an FTA or TRIPS or whatever it may be, that how those negotiations are designed and the outcomes that they produce need to have better and more informed inputs, whether it's from a public interest organization or from another thing. It's all about how those negotiations are designed, and your argument is that if they're designed better, if you have more input from these public interest lawyers, you're going to have better outcomes at the end.
I don't know about, I guess it's hard to say if you're going to actually have better outcomes at the end. What I would say is that from what I've seen at these events is that the negotiators from developing countries get a lot of their information from, so negotiators from the global south largely depend on reports and such that are written by public interest organizations in the global north, with inputs from a broad spectrum of who you would consider to be involved in public interest work, which includes lawyers, academics, general civil society and so on.
Yeah.
But their kind of legal advice at these negotiating sessions essentially depends on these public interest organizations. Not because they're unable themselves to develop kind of their own positions, but because a lot of times this is based on US law, and so the full implications of any of these given provisions is difficult to predict unless you've seen it operate in, for instance, your own country. Another element is informal meetings. Also recently, there was a release through a FOIA request, a Freedom of Information Act request, of something like 127 pages of emails between the USTR and their close advisors. Here you see some emails with pharma. These are all informal meetings that happen with USTR that more recently, actually, public interest lawyers have begun to solicit themselves after learning that this is really how a lot of policy gets made for these agreements. And they've had some success in doing so. Actually, a number of them are considering getting together. There's a problem that they face in that public interest organizations usually want more transparency, but a lot of times in order to arrange these kinds of meetings, they have to keep very quiet about them and they can't disclose that they even had the meeting, which doesn't really help too many people. Because it's in the interest of even the USTR for people to view them as more transparent. So this creates a very big dilemma for public interest organizations who don't want to compromise on their principles, but also really want to have some sort of input on what kinds of provisions they're what kinds of provisions are going to end up in these agreements. And finally, down here. There has been a big movement to get direct civil society input from individuals through a new website through Open Media, where you can fill out your own comments on your own thoughts on the TPP and what it should contain, and then this is all filtered by some public interest lawyers who then turn all the comments into their own recommendations to the USTR. So why is this all important? Why does it matter what these provisions say? Because it binds governments to follow them. If they don't, they can get sued by foreign investors. So two examples here are Eli Lilly suing Canada for $500 million after it got its Strattera and Zyprexa patents invalidated as under the Canadian Promise Doctrine. It's an element of their patent law which requires that a patent holder be able to demonstrate or promise a specific utility and somehow show clinical efficacy. And Australia, also Uruguay, being sued for their regulations requiring plain packaging of cigarettes. And again, this is another place where public interest lawyers have begun to try to find ways to get involved in this arbitration, which has largely been closed to a small group of arbitrators who are not known to be impartial. The ethics rules for arbitration are not what we know here, with our own code of ethics for lawyers. You can represent a party in one proceeding and then be an arbitrator in the next one, even if it's on the same topic. There's a strong pro-investor bias given that these proceedings are to protect investors. There's a lack of transparency. Only usually if it's agreed upon are actual decisions released, depending on what arbitration system you're using. And there's generally no consideration of the public interest, which we usually find as exceptions when courts are making decisions. Oftentimes they'll weigh public policy issues when deciding what to do. So policy spaces for North-South collaboration may not be too big at the very top. This is just the tip of the iceberg is what you can do within your own country, given that there's a great uncertainty about what then these international agreements will require. But four routes that public interest lawyers can use to influence what happens in their own countries, especially for developing countries and emerging economies, is to participate in the development of multilateral treaties. So this summer, we had a great example of the Marrakesh Treaty for the Blind being signed by WTO parties. And this was actually the first multilateral agreement that is thought of as not a more protective agreement, but as a more open agreement, which promotes access to copyrighted works rather than restricts access to copyrighted works. Public interest lawyers are also increasingly getting involved in influencing the decisions of WTO. Recently this summer, there were several congressional hearings I had the opportunity to attend regarding whether or not to commence WTO arbitration over India's recent actions thought to be discriminatory against foreign investors. Specifically with regards to the Novartis case and the decision that Section 3D of Indian patent law didn't allow for a patent on Gleevec, which was a new form of an old substance. And there are two initiatives allowing for public interest lawyers to assist developing countries. This one, ACWL, is basically like pro bono legal services for developing countries faced with investor-state dispute settlement proceedings when they can't afford their own lawyers because these proceedings can often be drawn out and very expensive. And Train Lab is an initiative, I believe run out of Stanford, which puts online a lot of advice and access to free advice about investor-state dispute for those who cannot necessarily afford fancier lawyers. And finally, as I've been showing, there has been a significant movement towards trying to change policy at the level of bilateral and regional trade investment agreements rather than within developing countries themselves. This here is a big petition by all these public interest organizations to keep IP out of TAFTA, which is public interest organizations' way of referring to transatlantic trade and investment partnership. They like to emphasize that it's actually a free trade agreement. But didn't mean to do that. But between all these different options, we've seen a lot of movement out of the domestic policy space and into the international policy space, and at the same time, a lot more fine-tuning and more technical expertise coming out of a lot of public interest organizations that are highly collaborative in terms of north-south collaboration that try to research issues and research the impacts on developing countries of policies that emerge out of the US. So, any questions? I think we have 10 minutes. Or
I know people have to go shortly, but I just want to give Adriana a round of applause. And then, of course, the floor is open for questions, or I'm sure Adriana will stay for a little bit if people have questions offline too as well.
Congratulations to you for taking, first of all, this kind of a topic. First time I'm hearing that, the public interest lawyering itself is the biggest thing in lawyering. And when it comes to IP, that's really an exceptional one. I really congratulate. Secondly, that the realm of things you have covered here, it really shows that what are the efforts being taken at the international level by various countries to infuse justice into the IP system. But at the individual level, what are the activities that people like us can do in changing the national laws or the international laws, or infusing those the values into the already existing domestic system? So what are the ways we can contribute? If you can throw light on that.
So, I'll have to base my answer on my own experiences working in India 3 summers. It's really where I've developed a lot of my experience or knowledge about, I guess, how within a country a public interest law firm can influence its own domestic policies rather than in these international fora. There, a lot of the work was informal submissions to the government on proposed policies. So in the absence of a public notice and comment procedure, some of these public interest organizations or law firms specifically still develop kind of informal relationships with certain individuals in the government, and through those individuals are able to submit these unofficial comments to proposed legislation. And my understanding is that those have been moderately effective. They have at times opened the eyes of certain people in government to issues that they hadn't considered. However, it's really unclear whether or not, it's actually those kinds of submissions that impact changes in the proposed policies or not. I'll have to think more about that question. But actually, I would invite you to share with the audience your own experience with your own project, because I think that's a fantastic example, better than any that I could think of. So if you'd like to share maybe for 1 minute or 2 minutes, I want to put you on the spot.
That'd be really wonderful, yeah. I've been working on the traditional knowledge or the indigenous knowledge, how that is important in for recognition. In the IP system, particularly the TRIPS agreement, the way in which now it functions, it mainly protects the invention based on the non-obviousness and the inventive step, utility of course. And if these three things are not present in particular situation, that's not an invention. And most of the inventions coming from the developing countries, you see that they have several traditional wisdom and they make it. And for centuries together they have been doing it. And they are useful, they have utility, and in many modern contexts, even if you see that there is an inventive step, but there is a non-obviousness. But non-obviousness is a slightly difficult part that for a long time it has been used, so it is obvious. It has become obvious to many people. But the inventiveness you cannot dismiss. So here there is a justice part that how to recognize these native wisdom of the people. The agreements don't recognize that. So I'm trying to fix that, how this traditional wisdom can be looked at as some of the productive measures under the existing systems. This is one thing I'm working on. And secondly, there is one more justice part that I wanted to highlight here, and Rihanna can take up this in this presentation maybe next time when you make. You have in fact given all the examples. One more example is that in India, particularly in education system, the right to education versus copyright system. The Delhi University has, I'm coming from Delhi University, I'm teaching there. Last year what happened is that there was a case filed against a photocopier for photocopying the materials for the students, for enabling them to read the materials, because there were 20 reading materials prescribed by the professors. If anyone has to buy, and they have to save huge amount of money. In Indian standard, it requires more than 1 lakh rupees. More than that, you have to, for a normal student, it would not be possible to buy.
That's like $1,000.
So either you have to get, this is a Delhi University photocopying case.
I was just, if you want to translate what the lakh means.
Yeah, that is 10 lakhs is 1 million. Okay,
More than
1 million. So this one, they are not able to do that. So the university has permitted a photocopier to take photocopies of select chapters. It is not the full book which is being photocopied. So select chapters, select portions of the books, and this has been given to the students. And at the photocopying cost, there was no marginal extra cost. It is not a commercial. It is the enabling education. So what happened is that all these the publishers, Oxford, all the other Cambridge University Press, every university, they filed a big case against the photocopier. So now the case is pending before the court in the, but they were successful in getting the injunction against the practice. Here the big question comes is that, wonderful that if I write a book, I have the right over the copyright. But at the same time, the affordability is one issue, accessibility of knowledge is another issue, that it should be easily approachable for the people. It is not that everyone can buy a book for $300, $500. It is not possible. So even in the developed world, kind of US, here that there is a minimum level that about 10% or 15% is allowed to take photocopy if you can read. It is not completely prohibited. Reasonable restrictions are always there. But even that was not applied there. They said that this is completely affecting the copyright system. But we have an Indian law which specifically says, as you said, that educational use, personal use, it is always permitted under the fair use provision. Okay, Section 51 of the Copyright Act says this. But even negating all these things, they have got the injunction. But the case is still going on. We are hoping that this will be. The students can win. The students are one party, the faculties are another party, universities another party. It is going like that. It is taking a new dimension of copyright versus the education, right to education. So these are the issues, in fact. So when the intellectual property regime, is imparted to facilitate the inventions, but at the same time we have to look at the public cost, public concerns. As you have asked, why we should give room for the public interest, people, not the technocrats or the scientists or the technical people. It's sure that in every negotiation you need to hear the experts because they know better. But they know better about their technology. They know better about their own specialization. You may not expect that they will feel for a person who is suffering something. So that is where the democratization of the decision-making process comes. So you have to hear. If I am a medical doctor and he is a patient, I'm sorry if I can refer so. You have to definitely, when you want to make a system for medical system, you have to definitely talk to a doctor because he knows better. But the pain is experienced by him. You should also consult him that what works better for him. So this is how the informed decision-making process happens. Unfortunately, what happens today in this the commercialized world is that it is the technology that wins. It is the investment that wins. So you don't feel about the public concerns. That's why the rich becomes richer, the poor becomes poorer, the pain becomes freedom.
Well, thank you again.